Good afternoon. Welcome to the HBA Appellate Practice Section's February meeting and CLE presentation. My name is James Merrow. I am an appellate lawyer and a partner with Wright, Close & Barger, and I'm the chair of the Appellate Practice Section. We have a terrific program today about the differences between appeals in Texas state and federal courts. This is a critical topic because there are key differences between appellate practice in state and federal court, including distinctions about important appellate deadlines and also about preservation of error. And those differences can trip you up if you're not prepared for them. Today, we're pleased to present a panel consisting of members of our very own Appellate Practice Section Council: Whitney Breek, Meredith Parenti, and Jill Schumacher. Whitney Breek is a shareholder at Boyer Miller, where she handles appeals and complex commercial litigation and arbitrations. Her appellate advocacy is primarily focused on Texas state courts of appeals and the Texas Supreme Court. Whitney began her legal career as a briefing attorney for the Honorable William J. Boyce and a staff attorney for the Honorable Sharon McCauley at the 14th Court of Appeals. She also served as an intern for the Honorable Don R. Willett at the Texas Supreme Court while studying and while singing and dancing in the law school musical at the University of Texas School of Law. Yes, Whitney is multi-talented. Whitney currently serves as treasurer on the council for the Houston Bar Association Appellate Practice Section, and she is a member of the Donations Committee of the State Bar of Texas Appellate Section. Whitney is a longtime member of the section's Pro Bono Committee, which helps to review applications by parties on appeal who are financially unable to obtain legal representation, and which helps to connect those individuals with volunteers who will agree to serve without expectation of compensation for their service. When Whitney is not buried in briefs, she serves on the board of the Houston Contemporary Dance Company and can usually be found chasing her 2-year-old toddler, Augustus, around the Oak Forest playgrounds with her husband, Gene. Meredith Parenti handles appeals and litigation before state and federal courts at every level. She has a broad range of experience across industries and subject matter, including bankruptcy, international law, and free speech. Meredith is board certified in civil appellate law by the Texas Board of Legal Specialization. She has been recognized as a top-rated appellate attorney by super lawyers every year since 2015. Meredith previously served as Assistant Solicitor General for the state of Texas, where she represented the state before federal and state courts of appeals, handling a number of significant constitutional cases. Meredith also served as a law clerk to the Honorable Kenneth M. Hoyt of the United States District Court for the Southern District of Texas. Meredith received her JD from the University of Maryland School of Law, where she was editor-in-chief of the Maryland Law Review. Meredith is an active member of the Appellate Practice Section, where she currently serves as immediate past chair. She was a regular speaker at continuing legal education programs on trial and appellate topics. Meredith spends her free time learning Italian, practicing yoga, trying to keep vegetables alive in her garden, and enjoying the great outdoors with her husband and law partner, Mark, their 3 children, and their 2 dogs. Jill Schumacher is a partner at Daniels & Tredenick PLLC, where she handles appeals and litigation. Jill has a diverse practice involving issues ranging from contract disputes to constitutional issues. Jill has served as counsel of record in federal and state appellate courts at every level. Jill is board certified in civil appellate law by the Texas Board of Legal Specialization. Before entering private practice, she served for almost 5 years as a staff attorney to Chief Justice Kim Thompson Frost on the 14th Court of Appeals, and before that, as a law clerk to Judge Francie Reedman on the Nebraska Court of Appeals. Jill received her JD cum laude from Duke University School of Law, where she served as the research editor of the Duke Journal of Gender, Law, and Policy. Before law school, Jill graduated summa cum laude from Washington University in St. Louis, where she earned the Helen Stenner Memorial Prize in Philosophy. Jill currently serves as the section's secretary. She has contributed her efforts to the legal community by writing and speaking on various legal education topics. Jill is not shy about wrangling others into her pursuits and even convinced her husband to co-author a series on cybersecurity for lawyers. Jill is a mother to 2 young children. She loves organized closets, philosophy books, and any seasonally themed activity. So with that, I will turn it over to our august panel.
Hello and welcome. We're very excited to present to you today on Texas and federal appeals, a compare and contrast and cautionary tales. This presentation was born out of my experience. I am primarily a state court appellate practitioner with briefing attorney experience at the Intermediate Court of Appeals and some intern experience at the Texas Supreme Court. So relatively green to federal court appeals. And, over the course of the past year or so have been invited by some of my trial teams in my firm to advise on appellate related issues in federal proceedings. And very quickly became aware of how different those can be on some what I considered pretty basic and fundamental aspects of appellate practice. So reached out to my colleagues who are here to present with me today because I know that they handle federal court appeals on a more regular basis, but to get their input and assistance kind of on a spot basis, but to put together this presentation so that we can give you a high level overview. If you're like me, venturing only infrequently into the federal court system or vice versa, this should hopefully help illuminate for you some areas where you may not know what you don't know. So we can start with error preservation and post-trial motions.
All right, so beginning with error preservation in the state courts, of course, there is a significant amount of jurisprudence on details of error preservation in a variety of contexts in the state courts. And so this is just a high level overview. By no means am I trying to hit everything. So in state court, preservation of error is governed by Track 33. Track 33 requires that a complaint be made to a trial court by a timely request, objection, or motion, and that the trial court have ruled on that request, objection, or motion. Or if the trial court refuses to rule or just says something like an objection is noted, then there's a requirement to object to the refusal to rule and also to get that objection on the record. I'm going to jump quickly to talking about a bill of exception because it fits right here. If you cannot get a ruling on the record, then there's a specific procedure to follow in Rule 33.2 to make a bill of exception to file with the trial court. If the parties don't agree on what happened, you want to read that rule quickly because you'll need affidavits from at least 3 bystanders who viewed the event and can attest to what happened. Now, also Rule 33 has a specific exclusion for challenging the sufficiency of the evidence in a bench trial. There's no need to preserve that in state court. Now, jumping to substantive areas, we'll start with summary judgment. There's a lot of different cases. This has been a very active area for the Supreme Court in the past few years. Generally, this area mirrors objections that you have to make in the trial court with respect to evidence, in that you need to obtain a ruling, and that ruling needs to be recorded. It needs to be recorded on the record. Now, some cases have said it's possible to tell from the context that the trial court has denied objections, but you're getting into fairly dicey territory. The Supreme Court of Texas has specifically suggested that parties incorporate their evidentiary rulings into their proposed judgments so that the trial court can rule on those in the final judgment. It's important to remember in the summary judgment context that the evidence is not just the documents that are stapled to the summary judgment and the response. It's anything that's in the record up until that point. Now, you need to have a ruling regarding any evidence that's in the record that shouldn't be there to support the trial court's judgment. But if the trial court judgment depends on evidence that just isn't in the record, that's something you can raise for the first time on appeal. This dovetails into another area where the courts have been fairly active, determining what kind of objections you have to make to evidence. If you have a substantive defect, there's no need to object to that at the trial court level. It can be raised for the first time on appeal, but a defect in form is waived if it's not objected to in the trial court. And there's a lot of case law on what is a defect in form versus a defect in substance, but defects in substance are disfavored. So it's always better to to go ahead and object. Now, in the trial, starting with jury trials, they begin with voir dire. Voir dire is an area where you want to have everything on the record before you or trial counsel you're advising goes into trial. You want to make sure you have your scripts ready because some objections need to be raised immediately. For example, when an objection to the array needs to be raised before voir dire even begins. And then in voir dire, to preserve a challenge, to preserve striking a juror for cause, there are several steps to follow, including making sure that you have documented your harm on the record. Evidence in the trial court, the first thing that's important to remember is that a motion in limine doesn't preserve anything at all. There's a requirement to object to the evidence when it comes in. And also, it's important to remember in state court that you weigh that objection. If you don't object every single time the same piece of evidence comes into the trial, you can run into issues with running objections too. You want to make sure the scope of any running objection is clear and is renewed with each witness. The jury charge is also an area of jury trials that has a lot of specific rules within Texas. There are a lot of cases on the timing of an objection. The timing has to be made before the court reads the charge to the jury or at any other time that the judge specifies. Also, the steps to preserve charge error are pretty detailed, and what you need to do depends on whether or not you're objecting to an instruction or question that is omitted versus one that's defective. And it also depends on whether or not you have the burden of proof on the issue that you're objecting to. In some instances, you need to submit a substantially correct wording, and there are specific requirements, for example, that it be in writing to the trial court in order to preserve error on an objection. The other thing in state court to pay attention to, of course, is Castile error, making sure that the form of the question is correct. For example, if you have a broad form liability question, making sure that there are not multiple potential theories of liability, one of which might be invalid. The other thing that you may run into in jury trials are challenges to the legal and factual sufficiency of the evidence. You can preserve a challenge to the legal sufficiency of the evidence in a variety of ways in a jury trial. There you could file a motion for a directed verdict, a JNOV, a motion for a new trial. You could object to a jury question. The important thing to remember is that each different way that you object, each different vehicle offers different potential relief. So for example, if you make your objection to sufficiency of the evidence in a motion for the trial, the only type of relief that the appellate court can afford is a new trial. Factual sufficiency in a jury trial is preserved through a motion for new trial. Now, bench trials are a little bit different. As I mentioned, Rule 33 does not require you to preserve a challenge to the sufficiency of the evidence in a bench trial. But one thing you do want to think about and watch out for is to make sure that you get findings of fact and conclusions of law. Because whether or not you have those findings really shapes the way that the appellate court will look at the issues when that court is looking at your appeal. If you don't have findings of fact or conclusions of law, the appellate court will uphold the judgment on any possible theory. It may not be one that the parties focused on. And so to make sure that you're not sending the court on a scavenger hunt to determine if there are any theories out there, you want to make sure you have those findings of fact and conclusions of law. The rule is pretty specific, though, on how you preserve error if the trial court doesn't make findings of fact and conclusions of law. Not only do you need to request them timely, but then if the trial court fails to timely make those conclusions of fact, those findings of fact and conclusions of law, you have to let the trial court know that their findings are past due. So that fundamental But in Texas, so there are a lot of specific rules and there's a lot of jurisprudence related to the specific rules, but you also see the courts focused a bit on the underlying principles and the spirit of the rules. And sometimes when those principles and spirit are met, even if you haven't preserved error technically in a proper way, as long as the trial court's been made aware of the error and had an opportunity to act on it at a time that mattered, sometimes courts will stretch to find error preserved. An example of that is you may have a motion to modify a judgment later on that isn't technically a motion for a trial, but as long as you word it correctly, you may be able to preserve a sufficiency of the evidence point or something like that. Moving on to federal preservation of error, Meredith.
Okay, so Whitney, if you could go forward another slide, thank you. In federal court, you can forget about all of those Texas style post-trial motions. And in federal court, it's all about the JMAL, the judgment as a matter of law. And under Rule 52, motions for JMAL are required to preserve error and challenge the sufficiency of the evidence on appeal. The first one is before the case is submitted to the jury. That's your Rule 50A motion. And the second one is within 28 days after the judgment is entered or the jury is discharged if you're addressing a jury issue not decided by the verdict. And that is called the Rule 50B renewed motion. So both of those are required. And it's tricky because sometimes state court practitioners will perhaps forget to file one of those. So it's just important to remember this. There are no extensions, so you have to get that filed within 28 days after the judgment for the second one. And the other important thing to remember is that that second JMAL motion cannot raise new grounds that were not in the first motion. So try to get all those grounds in the first motion, and then you renew those grounds. So, and I can't stress enough, you cannot fudge the requirement for two motions, and the courts are very clear about this. If you forget to file one of the two motions, then you will not have preserved error and cannot challenge the sufficiency of the evidence on appeal. Now, the only possible exception to this is if after you file your Rule 50A motion, your first JMAL motion, possibly a motion for new trial could get you to the point where you can raise a sufficiency issue. The Supreme Court in the Unitherm case referenced this, did not decide it directly. However, later, that was in 2006, but subsequently the Supreme Court in the Ortiz versus Jordan case in 2011 said that absent that second Rule 50B motion, an appellate court is powerless to review the sufficiency of the evidence after trial. There's some mixed case law in the Fifth Circuit, and they've recognized they're not entirely on this point about whether a motion for new trial can suffice if you forget your Rule 50B motion. But they pointed out recently in the Wick Fire case and just this year that it's, at least in some unpublished opinions, they've let a party slide where they had a motion for new trial instead of a Rule 50B motion. But I wouldn't bank on that. That's not a ringing endorsement of the practice when the court says, well, in some unpublished opinions, we've allowed it. So just, remember two motions. And so when you do file it, it does extend your deadline to appeal, and it's from the entry of the order disposing of the motion. So we can move to the next slide. Here's some other post-trial motions that extend the time to appeal if you're requesting amended or additional fact findings. And by the way, that the district court does that. You don't have to ask for it, unlike state court. It's just an automatic thing, which is lovely. You can a request for attorney's fees or to alter or amend the judgment, and a motion for new trial, and a motion for relief from the judgment under Rule 60. And that is limited, Rule 60 is limited to correcting clerical mistakes or oversights, or if you argue some mistake or inadvertence or surprise or excusable neglect, perhaps why you didn't file your Rule 50B motion, or some newly discovered evidence, fraud, or the judgment's void. There's a limited number of factors, or the catch-all, any other reason that justifies relief. So it's possible you could use a Rule 60 motion if you forgotten one of those JMAL motions. I don't know that it will get you there, but I have seen courts kind of construe motions to be a Rule 60 motion for relief. And then one other thing to note on all of these other motions is that each one has a separate timing. And some of them, like if you're seeking attorney's fees, you have to do that within 14 days after entry of judgment. And some Rule 60B motions, you have up to 1 year, for example, with the newly discovered evidence. So just be aware. We can move to the next slide. And here's just some other error preservation points, broadly speaking. Similar to state court, you do need to assert certain things in your, such as lack of personal jurisdiction, improper venue, and is insufficient service of process, or in your first responsive pleading. And Rule 12 provides that these defenses are waived if they are not raised in a motion under Rule 12 or in a responsive pleading. And they do have to be heard before the trial court, before trial, unless the trial court rules otherwise that it's going to be deferred. In Texas, there's a similar due order of hearings requirement that requires a special appearance to be heard and determined before a motion to transfer venue. But there's certain things that need to be heard up front. And on evidentiary rulings, they're very similar in federal court and state court. Federal Rule of Evidence 103 and Texas Rule of Evidence 103 are identical in that they both require that any error in an evidentiary ruling has to affect a substantial right of the party. So unless it does, it's not really worth bringing on appeal. One thing to note as well is in federal court under Rule 103B, it's similar to state court, but different. So in state court, if you've objected outside the presence of the jury, you don't need to renew that objection once the jury's back. That's okay. However, as Jill mentioned, you do need to keep raising your objections just so you don't waive error. In federal court, Rule 103B is broader, and it says that once the court rules definitively on the record, either before trial or at trial, then a party need not renew an objection or make another offer of proof to preserve a claim of error for appeal. So that is nice. However, I would caution that when in doubt as to whether the prior ruling covers the current evidentiary issue at hand, always raise an objection again. All right.
All right, turning to the mechanics of the appeal, which by that I think we're referencing kind of the starting process. We preserve error. Everything that's going to happen in the trial court has happened. Now you're getting ready to actually present something to an appellate court, making sure that you have the nuts and bolts covered for that part of the process. And starting first with finality, there's a public policy preference in Texas and presumably in federal proceedings as well that we want to defer review in most cases until the end of the proceeding in the trial court. So the jurisdictional grants for both Texas state appellate courts and federal courts of appeals are from either the final judgment or final decisions. And starting first with Texas, the requirement is that the judgment be unequivocally clear that it is in fact a final judgment. And by that, the standard is that it disposes of all parties and issues. So typically you're looking for everything to be wrapped up, including attorneys, fees, interest, all claims and all parties in one final order or series of orders that then become final by virtue of the last one, resolving all of the issues at hand. The trap rules for triggering the timeline to file for notice of appeal from a final judgment are from the moment that the judgment is signed. That's the language that's used throughout the rules. If a judgment is signed or something that looks like a judgment is signed after a trial, it's presumed final. There's the benefit of having gone through that type of proceeding, and the courts of appeals will defer to that. Otherwise, again, it must be unequivocally clear, and there's quite a few rabbit trails you can run down on whether your particular order, whether it's summary judgment or a series of summary judgments or a combination of different types of dispositive motion rulings, whether that is in fact unequivocally clear that it was intended to and does dispose of all parties and all issues, or if it, may have disposed of things unintentionally, but did so clearly enough that it's appealable. I strongly encourage looking into that issue if you have any doubt whatsoever, whether you're looking at a final order. You can waste a lot of time and energy appealing something quite a little bit too soon. The Court of Appeals will catch that and potentially dismiss your appeal if it is not in fact final and there's not another grounds for appealing it early. The federal finality question has been described by commentators as a crazy quilt, because there's a lot of different judicial decisions and legislation affecting whether something is in fact a final decision, which is the statutory grant under 28 USC 1291 for appeals to the Court of Appeals. The final decision is one that is entered. That's the Federal Rule of Appellate Procedure 4. That's the timeline that is triggered for you to file your notice once that judgment is entered. And the description for whether something's a final decision or final judgment in federal court is, does it end the litigation on the merits, which sounds to me like a much looser standard than the Texas one. And I think that there's some permutations that make it, that lend itself to being described as a crazy quilt of judicial decisions, and unacceptable morass, I think, is another way that commentators have described it. That's because it could be, you could end the litigation on the merits as to some, but not all parties. There's a scenario where that could happen. You may be resolving the litigation as to all claims and counterclaims except for fees, because of course you can request fees after a judgment has already been signed or entered or post-trial. And so if you have any questions about whether or not you are looking at what you think is a final judgment, that's the opportunity to take a close look at some of this case law that may directly impact your particular scenario. There's also on the state side, there's a really fantastic article by Professor Elaine Carlson that's in the South Texas Law Review that discusses kind of the evolution of the Texas Supreme Court perspective on finality of judgments in Texas that is incredibly helpful. One anecdote for me, having worked for Justice Bill Boyce on the 14th Court of Appeals, I remember him drilling into my head anytime we were writing an opinion that discussed when a judgment was signed. I think there's a lot of practitioners have a default of just saying a judgment is entered, an order is entered, just as kind of normal parlance. And he said, nope, the rules in Texas say when a judgment is signed is what triggers all the relevant deadlines. And when a judgment is entered in federal court, that triggers those deadlines. So if you want to nerd out over that with us, it could distinguish you as someone who's paying close attention to what the rules say, but I don't think anybody would blame you if you slip into the more common references to judgments and orders being entered, even if you're in state court. All right, notice deadlines. In Texas, that's dictated by TRAP 26.1. Most appeals, regular appeals, are going to be the 30-day deadline to file your notice. Accelerated appeals are a little bit shorter, 20 days. There's a post-judgment motion filed that will extend the time period from the judgment to when you have to file your notice, not when the motion is filed or when the motion is decided, but 90 days from when the judgment was signed. Restricted appeal, more nuanced, unique appeals can be up to 6 months. And then if someone in your case files a notice, then the other parties have an opportunity to file their own or cross notice 14 days later. Federal rules, it's Federal Rule of Civil Procedure 58 and Appellate Procedure 4. One note that I've bumped into is this separate document consideration. We had a case where there was a bench trial, a docket entry that was outlining all of the terms that you would need to include in what we would consider a final judgment. There was not a motion for fees following the trial. The court anticipated that the parties would be submitting evidence of that, but did not. There wasn't the need for a party to actually file a motion, so that wasn't going to extend the time period to. Is we're looking very closely at whether, in that scenario, if a separate document was never filed and signed and entered by the trial court, when would the notice have to be filed under kind of the longest extended time period under the rules. So do check if your particular ruling is required to be laid out in a separate document, and that's under 58. Things may not, certain orders may not have to be orders amending or making additional findings, granting attorney's fees, denying a new trial, or denying alteration or amendment of a judgment. So there may be things that are literally just entered in the docket that may affect what you're trying to appeal. Post-judgment motions, as Meredith mentioned, that will extend the time period to appeal, but it's from the entry of the order. Unlike the state court that just extends the time period post-judgment, it's from the actual ruling on that motion. And then the same cross appeal deadline, 14 days. All right, then moving to the clerk's office and just the administration of the appeal on the front side of things, including things like extensions that dictate the pace of your briefing. And all the other things that have to be filed. I think generally speaking, the state intermediate appellate courts and Texas Supreme Court have great clerk's offices. They're super communicative and open. You know, they host CLEs where they're constantly inviting people to pick up the phone and call them if they've got an emergency motion, things like that. I think the general sense is that on the federal side, it's very similar, that they're there to help you and trying to service the people who appear before the court. So use that liberally, because they're a vault of information that can help you for just getting everything done and timely, but also kind of advising you on preferences for what materials to bring to oral arguments and the mechanics of getting around the courtroom for a presentation and things like that. So do reach out to them. On the Texas side, if you're getting notices about kind of the status of your appeal and when certain things are going to start becoming due, 9 times out of 10, those letters are going to defer completely to the rules. They may have some general guidelines for you, but unless you're getting a notice about, extension of time that's actually been granted with a date certain where you have to file that brief, you still are probably going to have to rely on your own knowledge of the appellate rules to understand when you need to file what and when. Contrast that with the federal side, I think they are inclined to hold your hand a little bit more and will tell you exactly what has to be filed and when, which is helpful to have that guidance if you're not appearing in federal courts as often, but just be aware of that difference. Late notices of appeal in Texas, you can get those approved even if they're up to 15 days late, just with a motion with the Court of Appeals. In federal court, you have to file that request if you're late with the district court, and you've got 30 days to do it, or even longer potentially if there's excusable neglect or good cause. So you have a little bit more flexible standard on the outset. I can't speak to how it gets applied in actual practice, but do avail yourself of those remedies if you need to. All right, appellate records. So you've got to get all the stuff that the Court of Appeals needs to review to the Court of Appeals. That includes the filings and any transcripts and evidence that was presented for whatever was decided that you're appealing. In Texas, that's governed by TRAP 34 and 35. The big distinction is that on the state side, probably just by virtue of the fact that we don't have a PACER equivalent, the e-filing equivalent that is across all the different counties and different types of courts in Texas, you still have to request that your filings, your clerk's record be prepared. Now there is under, I think it's TRAP 34, where there's the default contents, just the bare bones basics, the pleadings, the judgment being appealed. There's some contents that will automatically be prepared by the clerk, and they have to do that in most cases in 60 days. But if you want to make sure you have everything in the record that you think is relevant, even if it includes things that are a little bit above and beyond what would just be the bare bones basics, do make sure you make that request kind of early. There's no real deadline to do that. You just want to make sure you do it before the clerk's record is prepared so that you get everything that you need. But I think courts in both systems are pretty flexible with supplementing the record as needed. They appreciate that they want a complete and accurate record from everybody's perspective. So if you leave something out, then jump to add it. Also on the state court side, you're going to have the docketing statement, no deadline to file that, but gives the court information about the parties and how to process that appeal. On the federal side, the clerk's record you don't even have to bother with. It's all the filings that are all available online for the courts of appeals, which is really nice. The transcript, there's a deadline of 14 days to request anything that was offered as evidence and transcribed on the record. And so you want to make sure you get that done in time. On both sides, if you are only requesting partial transcripts, there's a process to follow to make sure your opponent is aware of what issues you're trying to raise. And you need to follow that process to make sure that the Court of Appeals does not assume that certain facts that are omitted in that partial transcript would have supported the ruling that you're appealing. So those are good things to be aware of. All right, temporary relief. If you're starting your appeal and you know you have to do something to put a full stop on whatever's going on in the trial court, you have some options for how to do that in both systems. In Texas, it's TRAP 29 for regular appeals and interlocutory appeals, and then 52.10 for mandamus proceedings. For things that are happening while an interlocutory order is pending appeal, trial court can always supersede that through the kind of typical process, but you can also apply to the Court of Appeals for temporary relief for an order that would quote unquote preserve your rights while you're appealing a certain ruling. There's also an additional basis at the end of TRAP 29 for orders that would prevent the trial court from interfering with either the Court of Appeals jurisdiction or with whatever the effectiveness of whatever relief you're going to be seeking through the appeal. So there are a couple different options for how to present that to the Court of Appeals. And then a mandamus is broader. It's a stay for any other temporary relief. So appreciating that those circumstances can be pretty unique from one mandamus to the next. A response is not going to be needed for the Court of Appeals to grant you relief, but they're generally not decided shorter than 10 days after the motion was filed, unless you style it as an emergency. So if you've got an emergency, get it in. And if you see a motion for emergency relief that you oppose, get your response in. That's the advice on the state court side. Federal side is Federal Rule of Appellate Procedure 8. The biggest difference is that you've got to move in the district court first to get either a stay or some kind of a relief affecting an injunction order that's now going to be pending interlocutory appeal. Now you can move on appeal if your district court efforts are unsuccessful or for some reason would be impractical, but that is where you have to start first. Responses are due in 10 days by rule, but the motions can be granted sooner, so be aware of that. All right, so non-final appeals or non-traditional appeals, we've got interlocutory appeals, collateral orders, and mandamus proceedings. All right, so the statute that we're probably all most familiar with as state court practitioners is 51.014. We decided that this was not the most legible or easy to digest way to show the information, but it's probably the most familiar to you. Here's a quick shorthand version that lists out the current version of the statute that includes the new number 15. These are certain types of orders, rulings from certain dispositive motions in a certain type of case or brought by a certain type of advocate or party. And so you just want to make sure you check this list if you think you might have a basis to initiate an interlocutory appeal in the state court system quickly. Then you also want to make sure you understand if you do have a basis to avail yourself of one of these interlocutory appeals, understanding what is stayed in the trial court by default under the statute. Certain things are stayed just with respect to trial. Others are stayed with respect to all trial court proceedings. And then others, for example, special appearance rulings, there may be a couple others that have to check the provision, but there may be a time requirement for when that motion has to be filed or heard in order to benefit from the stay. The only time I've ever run into this was a special appearance proceeding in a case that was pending up in Dallas, where there was a ton of discovery related to the jurisdictional issues. And so the motion was filed, there was a fight over, or the special appearance was filed, there was a fight over whether or not it could be decided without that discovery. Then the discovery had to be undertaken. Then everybody had to kind of rebrief and represent everything. And we got really close to bumping up to, I think it's a 6-month time period in order to benefit from the stay if you need to appeal the ruling from that. So do make sure you're keeping an eye on your deadlines under the statute if you're going to proceed with one of these types of interlocutory appeals. Kind of an interesting development that I stumbled upon in working up the presentation was that in 2021, we actually had 3 different number 15s on this list. And I will leave it to the section to decide what the ultimate impact of all that may be. But quite literally, there's a version that went into effect on June 14th that had to do with interlocutory appeals from some new COVID liability legislation, a motion under that liability protection statute. 2 days later, you lost the right to appeal that potentially, and you instead had the right to an interlocutory appeal of a motion related to a protection for TxDOT contractors who were working, I guess, in kind of a quasi-governmental capacity. And then the current version that went into effect September 1st replaces those 2, and the June 16th and the one prior, and is now the current version, which is a preliminary determination of whether or not something's a healthcare claim for the purposes of that expert dismissal statute. So just be advised that that is a little more fluid than usual these days. But also you've got permissive appeals in the state and federal system. You've got interlocutory appeals that exist outside this particular statute. Appeals from denials of motions to compel arbitration or grants of motions to stay arbitrations. There's an interlocutory appeal if somebody's been improperly joined as a plaintiff or has intervened improperly for purposes of a venue determination. So just be aware that there are other sort of miscellaneous interlocutory appeals scattered throughout the codes if you want to consider whether yours is possible to appeal now. In the federal system, it's a much shorter explanation because it's a much shorter list. You've got orders on injunctive relief under 28 USC 1292 that you can appeal very quickly, orders appointing or maintaining receivers. In admiralty cases, you can appeal immediately the liability phase of the case because it can be tried separately, kind of in a bifurcated fashion, so you can appeal that quickly. And then there's a permissive appeal that's analogous. It's not completely identical to the state court system. And in fact, there was an article by Ryan Phillip Pitts in the most recent appellate lawyer this month about the scope of permissive appeals in Texas, kind of evolving over time, but also loosely contrasted with the federal court of permissive appeals. So highly recommend that. Some minor considerations: orders on injunctive relief are granting, denying, modifying pretty much across the board, but it could also be used to initiate an interlocutory appeal of things that don't quite fit within the traditional definition of an injunction. And so if you've got an order that is in some respects granting substantive relief early in the case, it's directed to a party, it's coercive and equitable, and it's enforceable by contempt, you may have a grounds to initiate an interlocutory appeal, even if it's not styled as an injunction. So be aware of that case law that's out there that you may be able to benefit from. If the Fed Circuit would have jurisdiction over a traditional appeal, they would also catch the interlocutory appeal of some of these types of orders. In most cases, it's not mandatory in either system to take the interlocutory appeal, but it may be, depending on your circumstances, you have to, if you can't violate an injunction, you have to file an interlocutory appeal if you want to be able to complain that it was improperly granted. And also there are closely related orders. This is something that I've never seen before in Texas jurisprudence, where if you've got an order that is subject to an interlocutory appeal under the federal statute, and there's some kind of closely related intertwined orders that otherwise would not be appealable themselves. You may be able to, through what's called discretionary pendent appellate jurisdiction, capture those in your appeal of the interlocutory order that fits within the category in the statute. So a little bit broader rights to get early relief if you need it for one of these types of proceedings.
Okay, so the collateral order doctrine is actually a lot more fascinating than you might think. It sits in the federal side. So on the federal side, under 1291, you have appellate courts have jurisdiction from final judgments. And as Whitney just described, under 1292, they have jurisdiction over certain interlocutory appeals. The collateral order doctrine is a pragmatic construction of 1291. And it allows appeals of certain judgments that are not, or orders that are not quite final, but have sufficient finality. The elements are that the order has to be conclusive, resolves important questions separate from the merits, and effectively unreviewable on appeal from a final judgment in the underlying action. And so there are some areas where, it's well documented, you'll have an appeal under the collateral order doctrine. An example of that is an appeal of certain types of immunity. In that case, the determination of immunity was conclusive. It resolved a question that was separate from the merits, and the courts have held that those are basically unreviewable because the purpose of the doctrine is undermined by the point where you're in trial. So there are those types of cases with just lots of cases holding over and over again with those are appeal, but there is a surprisingly wide range of cases that federal courts have held are appealable under the collateral order doctrine. So it's something to think about. Even certain discovery orders. Now they have to be really important discovery orders, but for example, in the Guantanamo Bay cases, the district court had ordered some documents unredacted that the United States had said were national security secrets. And in a case with the discovery order that's that important, courts have held something like that satisfies the collateral order doctrine. So there are, look all throughout federal jurisprudence, there are a number of situations that courts have said, yeah, that fits. In Texas, there is no formal collateral order doctrine. You'll see some of the same areas in interlocutory appeals. And the mandamus standard in state court has some overlap a little bit with some of the elements of the collateral order doctrine. I have seen cases where parties argued on the state court in the mandamus context, hey, on the federal side, this falls under the collateral order doctrine. So people have tried to make that argument as evidence that something in state court might fulfill the mandate purpose of mandamus relief, but it's a little bit mixed. You do see some strains in state court of certain types of cases where they have a similar flavor. One example of that is in probate, generally in probate cases, but if an order has sufficient attributes of finality, you might be able to appeal that a little bit earlier. Next slide.
Sorry.
All right, moving on to mandamus. So in state court, mandamus actions are governed by Trop 52. Of course, be aware that you're asking the court for equitable relief. And the Trop 52 does not have the mandamus cases don't have the same language about the courts, you have to bend over backwards to make sure that your right to appeal is not lost due to technicalities. And so it's important to follow the rules to a T. If your petition for mandamus is deficient, some courts may let you know and give you an opportunity to fix it, but others won't. The standard for relief is a clear abuse of discretion by the trial court and no adequate remedy on appeal. clear abuse of discretion means the trial court must have acted in a way that was so arbitrary and unreasonable as to amount to clear prejudicial error of law, or a failure to properly analyze the law or correctly apply the law to the facts. And that does apply even in areas of unsettled law. Whether or not you have an adequate remedy by appeal is a little bit more of a balancing act. Now, there are some statutes specifically say in this context, the party is entitled to mandamus relief. And there is also some case law, if you're challenging a void order, that will always be appropriate for mandamus relief. And the state court jurisprudence, there are a lot of different cases under a lot of different scenarios. So if you find yourself in any particular type of situation, there may be a case that directly discusses whether or not there's an adequate remedy by appeal for your specific situation. But if not, the review is based on you do not have an adequate remedy when the benefits of mandamus review outweigh the detriments. And there are some factors that the court considers. For example, whether is mandamus review essential to preserve important substantive or procedural rights? Are the courts in the mandamus context going to be giving helpful and needed advice on situations that often prove elusive, that they would not generally be able to opine on, only reviewing final judgments? And then will review spare parties and the public time and money wasted by proceedings that will, ultimately just be reversed? Meredith, I'll on the federal side of it to you.
So in state court, as Jill was explaining, there's really room for some creative advocacy. And, even if there is a case, you have a case that's never been mandamus before, there's room you can argue that your case kind of fits that mold and meets the standards. In federal court, by contrast, my advice is don't get your hopes up. Mandamus is truly an extraordinary remedy. It's governed by the All Writs Act. It just happens a lot less in federal court than state court. And it's really restricted. And so it's the rare case where a mandamus is appropriate in federal court. It's only available, the standard is a little different from state court, but similar. If there's no other adequate means for relief, the right has to be not just clear, but indisputable. And the court, as in its exercise of discretion, has to be satisfied that issuing the writ is appropriate. So it's really, there is not as much room for creative advocacy. You can try, but there may be other avenues that would be better. You'd be better off pursuing, such as the collateral order doctrine in federal court. And it's just something you just need to be aware. Go look and see what the case law, shows. If you've got something where mandamus is appropriate, great, go ahead and seek it in federal court. I had an interesting case where I was opposing a mandamus that had been granted by the Fifth Circuit from a denial of remand. And they had relied on an unpublished decision that supported their use of mandamus in that circumstance. And on rehearing, I pointed out, well, actually, there's about 100 years of precedent that says you shouldn't be granting mandamus in that circumstance. And so the court actually on rehearing said, oh, you're right. We're going to deny the mandamus. However, they did drop a footnote that was unfortunately doomed our position once we got back in the district court. So I don't think they were pleased. But at any rate, it's pretty rare.
All right, well, that concludes our presentation. Thank you so much for listening. And if you have any questions that did not get answered in the chat during our discussion, then feel free to reach out to any of us. We'd be happy to talk through whatever federal or state appellate question you may have. Thank you.
Thank you to Whitney Breek, Meredith Parenti, and Jill Schumacher for that informative and entertaining presentation. Thank you too to BWA Video for handling our video and live stream needs today. If you have any video, presentation, or live stream needs, please reach out to them at bwavideo.com. Thank you all for joining us today. Our next luncheon will be on March 10th in person, when we are honored to present Justice Ken Wise, who is a Texas history buff with a podcast, and he will be talking to us about a unique aspect of Texas legal history. We look forward to seeing you all then.